Good morning. We are live. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. Today is a live Q&A, and you are welcome to submit questions in the chat box below. Your questions get highest priority because you are here attending live, and I want to be as responsive as possible to those who took the time out of their day to attend live. Let's jump into the questions. Should you put a cabin in an LLC? I was recently asked this question by a business owner. So here's the context. Imagine that you are a business owner and you own a cabin, and you may have a lot of guests using that cabin. These guests might use it with you, but they might use the cabin without you present. Maybe those guests are using some of the stuff you have up there, like maybe the campfire, maybe there's some equipment, maybe they're swimming in a lake, and there are risks of drowning. Of course, that's always present with a lake. There might be some sort of incline or steps that somebody could fall or trip down or roll down. There might be an oven that could have a gas leak. In other words, there are all sorts of potential dangers around there. What sort of protections can you implement to minimize your risks? One option is to have that cabin in an LLC. Now let's differentiate a couple pieces to this. First, the cabin can be owned by an LLC. Second, the cabin can be managed by an LLC. So there are a couple risks here because in general, when somebody is looking to sue the owner of a cabin, they're suing them for some sort of negligence. And so let's say, for example, somebody gets hurt, one of the guests, or maybe a friend or a guest of theirs gets hurt on the property. And their allegation is negligence, that somehow there was negligence on the property. Now, by the way, you might say, stop right there. My guests would never sue me. But here's the problem. Often they don't have a choice. Say, for example, a child gets injured and has $15,000 worth of surgery due to the injury. When those medical bills are submitted to the health insurance company of the child, the health insurance company gets to decide whether to pursue a lawsuit against whoever was negligent at the cabin. Now, it is possible for the person or the child who's injured not to submit those medical bills to the health insurance company, but that's extremely unusual. It's very typical for people to say, hey, I have health insurance to cover injuries, so I'm going to submit that to the health insurance company. My point is, your guest may not be the one deciding whether to commence a lawsuit for negligence. It might be their insurance company. All right, so let's say there's a lawsuit. The question then is, who is liable for the negligence? Who is responsible for avoiding negligence on the property? So say, for example, an axe, which was used to chop wood, was accidentally left out. Well, it's probably whoever is responsible for managing the property. It's probably their liability. So what you can do is you can have an LLC responsible for managing the property. And that LLC can have a contract with those who are renting the property. This is fairly typical in like the Airbnb option or VRBO. You are essentially renting from a company that's managing the property. And that might be Airbnb or VRBO. And behind that might be another management company, and that's the owner of the property may have set up an LLC for that. All of that can provide some protection as long as there's a contract between the guest and the LLC. But if you're not planning to have guests sign a contract, then they're not going to sue for breach of contract, or they're not going to sue for claims under the contract, and you don't have a contract governing that relationship, which means they're suing probably whoever owns the property. And in some states, you can sue the property owner even if there's a contract with an LLC. So, where are we at so far? Just to summarize, having an LLC can provide some protection as long as there's a contract between the management company LLC and the guests who get injured. Now, another option is to have an LLC own the cabin, but you still have that LLC will still have liability up to the value of the cabin. So with the management company, it may have virtually no assets in it. So that management company LLC might get sued and they might just go under. They might go insolvent. And even if they lose a lawsuit, they have no assets to pay. Whereas if the cabin is owned by an LLC and that LLC is sued, then at least the value of the cabin can be lost in a lawsuit for negligence. And as you can see, we're getting a little complex here because for every LLC, now you need a tax identification number, which is called an EIN. You need a bank account. You need contracts. And so we're creating some legal formalities that are going to require some legal expense and some time and investment on your part. So if you want to set up an LLC, it can provide some additional protection. And in fact, you could have two LLCs. One set up to own the cabin, the other set up to manage the cabin and the rental agreements with the guests. If you set up an LLC to own the cabin, you will need to transfer legally the property into the name of the LLC. That's done through a deed. The type of deed is usually a quit claim deed that's spelled QUITCLAIM That is usually the type of deed that you would use to transfer your cabin into the LLC. One other consideration is getting insurance for the cabin. I actually think this is a great option for most people because it's an easy first step that just costs money to get some protection for any sort of accidents that occur at the cabin. All these LLC options add a lot of complexity. A lot of attorneys are willing to set up all these LLCs and formalities and contracts. It generates some legal income for the attorneys and it provides some protection for you. But I think the most protection is usually through an insurance policy that is designed to protect you in case of these sorts of accidents or injuries. So my suggestion first is get an insurance policy that covers guests at the cabin. And then if you really want to protect yourself, or if you have a lot of assets exposing, so say you have significant assets yourself, or it's a very expensive cabin and has a lot of equity. In those scenarios, you may want to talk with your attorney about setting up an LLC to manage the cabin and setting up an LLC to own the cabin. One other quick side note, if you have a mortgage on the cabin, there may be some complications with transferring the deed of the cabin into an LLC. Usually you can do it because you are still the owner of that LLC, but there are some complications that go beyond the scope of this video here. So hopefully that answers a question of should you put your cabin in an LLC? Short answer is it can provide some protection from liability. You'll need to think about whether you have a LLC for managing the cabin, an LLC for owning the cabin, or both. And either way, I recommend making sure you have a good insurance policy for any guests who are using the cabin. Okay, I'm going to take a look at the next question here. All right. This question is similar. Should you put a cabin in a trust? There are a couple different types of trusts: revocable trusts and irrevocable trusts. And have very different purposes when it comes to cabins. What is a revocable trust? A revocable trust is a trust that you set up and you can change it or revoke it at any time. What is an irrevocable trust? It's a trust that you set up and you give up the right to change or revoke it. You can't pull it back. It's set in stone. Now there are some extraordinary exceptions where the trust can be modified. Those exceptions are with a trust protector provision and with approval of all the beneficiaries. But I'm not going to get into that level of detail right now. Let's talk about how a cabin can use a trust. And let's first talk about irrevocable trust. So, how can you put a cabin into an irrevocable trust? You set up an irrevocable trust. You use a deed, usually a quitclaim deed, to transfer the cabin into the trust. And because that trust is irrevocable, it cannot be changed. And usually you are using an irrevocable trust so that the cabin will be preserved for the purposes you designate beyond your lifetime. You may be the trustee, which means you manage the trust during your lifetime, but then you could set up a successor trustee. That's somebody who will manage the cabin after you. It might even be a committee of family members. So, an irrevocable trust is often used to put a cabin or other land uh, into a trust for protection for generations to come. For example, maybe you want your children, grandchildren, and future generations to have access to the cabin and be able to set rules regarding how it's shared and who maintains it, etc. We can talk more about how to set something like this up in a future video if you're interested. Feel free to add a comment below if that's something you would be interested in, and I can talk you through all the considerations and some of the questions to ponder prior to setting up an irrevocable cabin trust for your family. Let's talk about a revocable trust for a cabin. Why would you set up a revocable trust for a cabin? Usually it is for estate planning purposes because you want to bypass probate. What is probate? Probate is the legal process and the court hearings related to transferring all of your assets and property to whoever you designate in a will. A will does not bypass probate. A will is the instructions for the court in probate. If you want to bypass probate, you use a trust, and usually a revocable trust, because as you age, you may want to make changes to that trust. So by reserving the power to make changes to the trust, that trust is considered revocable. You can revoke it, you can change it, you can amend it, you can do whatever you want with it, because the whole idea is you want to put your wishes in place for the time of your passing or when you are incapacitated. So if you set up a revocable trust for your cabin, that usually means you want to preserve your right and power over it while you have mental capacity and prior to your passing. And then after that time, you want it to pass to your heirs, whoever you designate. Okay, next question. Are umbrella policies worth it for individuals or small businesses? Umbrella insurance policies are policies that are an umbrella over the other policies you may have. So, for example, you might have a homeowner's policy that covers damage to your home. You might have an auto insurance policy that covers damage to your vehicle or damage you might cause to other vehicles. You might have other insurance policies. An umbrella goes over that. And there are usually two purposes for an umbrella policy. First, it enhances the protection you have on all of the other policies. It increases the amount of coverage. So, for example, in your home, if you have $1 million in coverage, an umbrella might increase it to 3 or 4 million. The other benefit to an umbrella policy is it often adds some additional types of coverage, like for defamation. What is defamation? Defamation is when somebody makes false statements of fact about somebody else, and those statements are likely to harm their reputation. And those statements are made to third parties. So, for example, if somebody said, John Smith is a murderer and a violent person, he just hasn't been caught yet. That's very clearly defamation because it is a false, we're assuming John Smith is not a murderer. In that case, it's a false statement of fact, has a likelihood of harming John Smith's reputation because murderer is not a good thing, and assuming it was made to third parties. So if it was posted online, for example. So let's say the person who made that statement had an umbrella policy that covered defamation. And let's say John Smith sued that person. When the person gets sued, they can say, oh, I have an umbrella policy. I am going to turn this lawsuit, this claim over to my insurance company, and they will defend me. Now, there might be some exceptions. Often there are exceptions for intentional acts. Usually that does not apply to defamation. But for example, if you go punch somebody in the face and you get sued, usually that is not covered by an umbrella policy. So you do have to look at what does the umbrella policy cover. By the way, insurance policies are just contracts. It's a contract between you and an insurance company that says, if I get sued for something, you will defend me and you will cover my liability. And in exchange for that, I'll pay you an amount every month or every 6 months. We call that a premium. So I love umbrella policies because usually they are not very expensive and they provide a lot of additional protection for you, like defamation. When I say not very expensive, usually they're less than $500 from my experience for most small business owners, and that's $500 per year. Second, they are increasingly important in this era of social media, where if you post something on social media, like say you give a rating on Yelp about a business, or say you post something on Facebook about your interaction with a product or with a company's service. These days, companies can sue you for defamation if there are false statements there. It's so easy to post stuff online. So unless you're the type who's just never putting yourself out there, I often think an umbrella policy is a great option for individuals and small businesses because it's so inexpensive. And when you need it, it can save you a lot of money. All right, let's go to the next question. What happens if you get sued but never knew about it? You might wonder, how could this possibly happen? Well, there are a couple different scenarios. If the person suing you cannot track you down, they can ask the court for permission to post a notice of the lawsuit in the local legal newspaper. And assuming the court determines that they've made reasonable attempts to serve you and that's been unsuccessful, the court may authorize you to be served by publication. Now, most people don't read legal newspapers. These newspapers don't even have to be posted online. So let's assume notice of the lawsuit against you is done by publication in a legal newspaper and you don't read it. Because you don't read it and you obviously don't know about it, so you can't respond to that lawsuit. When you don't respond to the lawsuit, the other side can bring a motion for default judgment. That just says they can ask the court to rule that you lose in the case because you failed to respond. So now the court, let's assume that the court issues a default judgment against you. And now what we have is a piece of paper from the court that says you are wrong, you lost this lawsuit, you are liable for whatever was at issue in the case. Let's say you owe $100,000. The party who won in that case against you can take that judgment and get a lien on your real estate, garnish your bank accounts, garnish your wages, and seek a sheriff's sale or an auction of most of the assets that you own. So all this, and that's typically when people find out about this. The case goes on, they never get notice about it, and then all of a sudden they get a notice posted on their door that their home's being auctioned, or the sheriff comes and serves something on them, or a sheriff will come and say, hey, this is a writ or a notice of a right to take something. That's normally when I get some sort of urgent call from somebody who says, I don't know what's going on here. They say there's a judgment against me. How can this happen in a country like America? My constitutional rights are being violated. This is extremely egregious. This is injustice. I want you to go to town. I want you to sue everybody involved. And I've had these calls. It's just an extremely emotional and frustrating situation for somebody who didn't know about the lawsuit. All right, so what do we do about that? I'll tell you in just one moment, but there's one other scenario that can lead to this. If you are a company operating in other states and you have not registered to do business in those states, you may not get notice of those lawsuits. As a company entering into contracts in another state or selling in another state, offering services in another state, hiring employees or independent contractors in that other state, you are required by state law in those states to register as doing business there. It's called a foreign entity filing or foreign LLC registration or foreign corporate registration. You have to do that with the state agency that manages corporate registrations or incorporation of LLCs and corporations. If you don't do that, you may never know about a lawsuit because the lawsuit is served on the state agency who manages that, and they don't know who to forward it to. So if that occurs, your company might get sued without your notice. I've had these calls before. They're extremely frustrating for small business owners because they find out for the first time there was a lawsuit filed against them. They never knew about it. They lost that lawsuit, and now their bank accounts are being frozen. You might have $150,000 frozen in your bank account, and this is the first time you are hearing about it. Okay, so what do you do? In both of these scenarios where you are hit with a lawsuit you never knew about, we can file in court. And we probably also send a notice to any bank institution or sheriff, putting them on notice that we are challenging and disputing any lien, any garnishment or replevin or levy action being brought against you or your property. So we put everybody on notice who is trying to take action against your stuff that this is being challenged. And we file in court, and we may request an emergency hearing if needed with the judge. Typically, this is in the form of a temporary injunction, which is sometimes called a temporary restraining order. But in the context of property, it's usually, at least in Minnesota, called a temporary injunction. And we ask the court first, put a hold on all of these actions that are trying to take our stuff. And then second, we ask the court to reopen the case and consider whether to undo the default judgment. So that is an emergency action typically done so that you can try to get the case reopened. Usually you have to show a couple things in order to get that case reopened. One is that you didn't have notice of the case. And two, you have substantial defenses or arguments that were not taken into account here. So what happens if you get sued but never knew about it? You file for quick action with the court to ask the judge to put a hold on everything, allow you to be heard, and try to get that case reopened. Next question. All right, I see a question just came in here from the comments. The question is, if you run a service business, do you charge tax for labor? I think what this is asking about is sales tax. It used to be that sales tax often just covered the sale of goods or products. It didn't cover the sale of services. However, state legislatures have been gradually changing those state laws to start covering services as well. So that if you sell a service, you may be required to collect and pay sales tax on that. Right now in Minnesota, for example, for a lawyer or an accountant who provides services, we are not required to collect sales tax from our clients, and thus we are not required to turn over that sales tax to the Minnesota Department of Revenue. However, there are categories of companies that sell services and are required to collect sales tax and then are required to turn over the money collected for sales tax to the state government. So this issue very much is decided by state law. Every state is different, and at least in Minnesota and states like it, it's going to depend on which industry you are part of. So you might wonder, how do I figure out whether I need to be collecting and paying sales tax from my customers or clients? The best option is to contact the state government agency that handles sales tax. Now, if your state doesn't have sales tax, you don't have to worry about that. But contact them and say, could you point me to any publications or laws related to whether sales tax is required in this industry? And then tell them what industry you are in. For example, maybe you are a personal trainer at a health club, or maybe you are a health club that sells memberships. Maybe you are a photographer and you provide photography services. But then, as part of that, you might include providing a digital form of the photos, which might be considered goods. And so, this is unfortunately not an easy calculation because sometimes it's not entirely just services. You might have some goods. Maybe it's just in electronic form. Maybe it's just an electronic copy of something that are that's being provided to your customer. And in that case, the calculation of whether you must charge sales tax may change depending on what you're providing to customers or clients. All right, I see additional context here for this question. So the question is, if you run an exterior cleaning service business, are you required to collect and pay sales tax? Uh, Unfortunately, I'm not going to be able to answer that question right here today. What I would do is step one, contact the sales tax department in your state and ask for any printed information regarding your type of business. Second, I'd encourage you to reach out to a CPA who handles small businesses. CPAs tend to have a lot more knowledge than attorneys on the specific tax rates because that's the world CPAs live in. Whereas even tax attorneys are dealing with more big disputes, not necessarily applying the tax rates. So, generally speaking, in Minnesota, a lot of service providers are exempt from collecting sales tax, but there are more and more exceptions these days. And frankly, I am not familiar with all of those exceptions. I'd recommend contacting the Department of Revenue and the Sales Tax Division or a CPA to get an answer for whether you should collect sales tax from your customers. Next question. Should creators look for investors? So I assume that this is a question around like YouTube creators, content creators, social media creators. Maybe you have a TikTok account. Whatever it is, if you are a creator online, or maybe even you're creating some sort of products or clothing attire or something like that, should you look for investors? When you have investors, they are owners. So, investors is just another word for owners. When somebody invests in your company, you need to figure out which category are they. So, if you have an LLC, they're going to be members or owners with a percentage of ownership. If investors are investing in a corporation, they are shareholders. Now, I suppose you could say somebody's investing in you if they're lending you money. But if that's the case, we would call them a lender, not an investor. Investor usually means they have an ownership interest in the business. And what comes with that ownership interest? Usually it's voting power, it's a right to veto things, it's a person who now has a right to financial information about the company and other information about how the company's doing. So essentially, when you are bringing on an investor as a creator, you are bringing on a partner, a business partner. And that doesn't mean somebody who's going to contribute more than, say, money, but it does mean they'll have all sorts of ownership rights in your company and will have a say in what you're doing. Often, creators are interested in their business because they built it by themselves, they like that independence, they have creative. Um, they love the creative independence, the ability to pursue the latest idea they have, and they're not really interested in having some investor second guessing what they're doing. So I generally think creators are best if they can bootstrap this, which means fund their business themselves. unless there is an extraordinary opportunity that is they are not able to leverage without an investor. So say, for example, the creator's YouTube channel is just doing great, and they now want to create a product line. Usually what I would do in that scenario, I'd advise the creator to create a business around the product line, but still preserve the YouTube channel as their own property. Now, the investor might say, no, I want that YouTube channel in the company because I want to have intellectual property rights in the YouTube channel. And then the creator needs to decide, are you willing to give up the intellectual property rights to your channel in exchange for this money and opportunity? The deals that seem to work, well, it can be done all different ways, but usually we are parsing out the intellectual property rights that the creator has established, and that is separate from what the investor is coming in and focused on. Often the investor's money will be used to hire a manager of the business and grow out a portion of the business. And there will be an agreement between that company, we'll call it a corporation, and the creator regarding what the creator is going to continue to do to support the corporation. Usually, what that means is bringing attention to the merch, the products, the services, the merchandise available at the corporation. And so it might say for a period of time, there are going to be promotions and mentions by the creator about the merchandise available for sale at the corporation. And then what happens is all the revenue from the merchandise goes into that corporation. It covers the expense of the corporation. And then to the extent that corporation has profits, that those profits are divided between the investor and the creator, depending on what the ownership percentage is or what the agreement is between the creator and the investor. So the one thing I really caution creators about is giving away to an investor the intellectual property that you have spent years building. Because as a creator, you've taken a lot of risks. And if you're at the point where an investor wants in, they want in after a lot of your risks are in the past and they've worked out in your favor. But they're buying in at a point where it's much safer than when you were a startup. And so my advice to creators is usually keep your intellectual property within your control because that's usually what creators want. And let's carve out exactly what this company is doing, what the investor is bringing to the company, and be real intentional about your rights if things don't go well with the investor. All right, we have a related question. How can music artists avoid paying everything to the music label? One of the problems I see time and time again, and I've seen some comments on this YouTube channel, music artists will say, I signed a contract with a label very early in my career. And now, as I'm making a lot of money and I'm doing all the work, the label is taking most of the profits. And that doesn't seem fair. They often say, I didn't have an attorney look at the contract. Is there anything we can do about that? Because I didn't know what I was signing. I was 18 years old. I signed a contract. So whether you are a creator online signing up with an investor or an artist signing up with a music label or an agent or an agency, whenever you're signing away future rights to your intellectual property, your creation, I highly recommend you spend the money to consult with an attorney. You can even say, I want the label to pay $500 to have an attorney review this or $1,000 or whatever it costs. but it's essential that you understand what you are giving up. Now, understand from the music label side, they are going to pump a lot of money into you and many other artists. And many of the artists aren't going to work out, but they're taking a gamble, a risk. They are hoping that among the 50 artists that they invest in, for example, that 5 of them do well. That might be 1/10 of the artists they've invested in. So they lose money on 45 artists, but they may make money on 5 of them. You might be one of the 5. And so they're out a lot of money, but they're hoping that you can help cover their losses with all these other artists and make them some more money. So although for you, it may feel unfair that you're making a lot of money now and have been very successful, and the label is making most of the profits. The idea is you agreed to the deal because at the time you wanted all the promotion and services and investment that the label could put into you. Now, ideally, you don't need to have a label. You pay for the studio time yourself. You hire any of the people you need to yourself. You set up all the concert venues yourself. You do the down payments on those. You do all the promotion yourself. And these days, we're seeing more of that because bands are able to put themselves on TikTok and other social media platforms and build their own listener base. And by doing that, they're able to preserve more control and more ownership of the profit rights as they are successful. But many artists say, you know what, I don't want to do all that. That's a lot of the work and operations of a business. I just want to create music. I don't mind giving up substantial profit rights to a label if they're willing to manage all that other stuff for me. And that's how the music industry is built. It allows artists who want that to delegate all of the operations and business administrative side and promotions to somebody else. It leaves for the artist the creation of the music, the performance of the music, and the artist's part of promoting the music. And then the artist is giving up substantial profit rights down the road if the artist is successful and generates a lot of revenue. So going back to the question, how can music artists avoid paying everything to music labels? Short answer is you can do it by yourself without hiring the music labels, or you can negotiate a deal with the music labels that at least preserves certain rights for yourself. And that's where hiring an attorney before you sign a contract with an agent or a label is so important. And again, you can ask the agent or the label to pay for your attorney fees, but you need somebody, an attorney, looking out for you who can explain to you what you're giving up in exchange for signing a contract that gives over your intellectual property or future profit rights. The next question, did Minnesota ban non-solicitation agreements? No, it did not. Minnesota banned employment non-compete agreements that are created after July 1st, 2023. But it does not include non-solicitation agreements. Let's talk about what the difference is there. Let's say you are an employee and you work at a company and you sign a non-compete agreement. What that means is you are agreeing not to compete with them. And usually there's some sort of geographic limitation. So within a 20-mile radius of the company, you will not compete. So as long as you take a job outside that 20-mile radius, or you start working for an employer outside that 20-mile radius, you may be fine. But that's what a non-compete agreement is. It says you can't compete. A non-solicitation agreement is very different. A non solicitation agreement says you will not solicit or ask certain people to work with you in the future. For example, a non solicitation agreement usually says you will not solicit customers of your employer, employees of your employer, vendors of your employer, or others that have a relationship with your employer. So, for a period of time, let's say for 2 years, you may agree you will not have any sort of relationship with those categories of people who already work with the employer. The idea here is the employer doesn't want you to leave and then ask people to go with you. So, for example, let's say you have a non solicitation agreement that says for 1 year, you will not solicit any employees of the employer. You can, and there's no non compete. You could go compete with the employer, but you could not hire one of your former coworkers to join your business until that non solicitation agreement ends. So that's the difference between a non solicitation agreement and a non compete agreement. Minnesota banned certain non compete agreements in Minnesota. It did not ban non solicitation agreements. Non solicitation agreements remain lawful and enforceable in Minnesota. What is the difference between non compete agreements for employment versus other types? Many states make a distinction between non compete agreements in the employment context, so that's between an employer and an employee, and non compete agreements between companies. So, for example, let's say a company is buying another company and they decide to have a non compete agreement as part of that process. Most states will enforce that, even though states may ban non compete agreements in the employment context. I'll give you an example. Imagine that you are buying a company and the owner of the company is 60 years old and she has great relationships with all of the customers of the company. And you are paying $1 million for this company. Well, once you buy the company, you are expecting those customers to stay with the company. So you might ask the owner who's selling her company to you to sign a non compete agreement. In a vast majority of states, that non compete agreement is going to be enforceable because it makes perfect sense that the company owner should not immediately start competing with you after selling the contract or the company to you. That is a very different scenario from an employer at a gas station asking the gas station attendant to sign a non compete agreement, which says the attendant will not work within 50 miles of that gas station at any other gas stations. In the scenario where the business owner is selling the company, of course she shouldn't be competing. But for a gas station attendant, why should they not be able to work at another gas station? How is that really going to hurt the owner of the gas station? And because of those sorts of scenarios, many legislators have said we need to protect employees so that they have a right to earn an income. And if, for example, if a gas station attendant wants to go work at a gas station a mile away, they should have every right to. Why should they have to drive now 50 miles because they signed some sort of non compete agreement? So there is a push in state legislatures to be more uh, differentiating in the types of non compete agreements that are allowed versus banned. Now, in Minnesota, we have a very uh, strong and broad ban on non-compete agreements because it isn't just employees, it also is independent contractors. And there are not certain exceptions built in that we may see in other statutes. That said, it's very possible that the Minnesota legislature will come back next year and tweak this law to fine tune it a little bit. It's pretty common for legislatures to pass a broad law first because they really have to work to get support for it. And then they come back and clean up some of the language a year or two later. Next question. What is a proxy or a proxy vote? Proxy essentially means substitute. So if you are a shareholder of a company and there is a shareholder meeting, you may want to attend so that you can vote at that meeting. But let's say you can't attend because you are out of the country at that time. You can usually sign a proxy which allows another person to vote on your behalf. Technically, it's called a proxy agreement, and that person becomes your proxy or your substitute. And by signing that, you are authorizing somebody else to vote on your behalf. Usually, you are going to assign your voting rights to another shareholder so that as that shareholder is there voting for their own shares, they can also vote for your shares. So you might have a proxy agreement with 10 shareholders who all agree that one person can cast votes for all of their shares. So proxy just means substitute, and a proxy agreement is where you are selecting a substitute person to vote on your behalf or speak on your behalf. And that person is called a proxy. Okay, let's take a look at the next question here. What is a trust? I had been practicing law for a number of years before I started learning about trusts. It's such an unusual concept, and it is very confusing for many attorneys, if not most attorneys, because you don't have to take trust law in law school. So most law students do not learn about trusts to any significant extent in law school, which means then that the only time you're going to learn about trusts is if you work with them or you decide to do independent study. And I did both. And so I spent a number of years working with trusts and studying all the different types of trusts. And I'm going to try to break it down really simple so you can understand what is a trust. You know how state legislatures set up corporation laws that explain what a corporation is and how they work, or what an LLC is and how they work? Well, state legislatures have also set up trust laws that essentially explain what a trust is and how it works. State trust statutes are all modeled after the same body of laws. And so there's a lot of consistency between many of the state trust laws, but it still does matter which state was the trust formed in because it is those state statutes that will be relevant to your trust. So, what is a trust? Well, just like an LLC or a corporation is a fictional entity, a trust is a fictional entity. A trust is this entity that is set up merely by signing a trust agreement. Yeah, as a general rule, trusts do not have to be filed with a state, they don't have to be registered. And so, although LLCs and corporations have to be registered with the state, A trust can be a private agreement between the person setting up the trust, we call them a trustor or grantor, and the person who is managing the trust. We call that person the trustee. Now, interestingly, the trustor and the trustee can be the same person. So I can set up a trust managed by myself where I'm signing both as the trustor and the trustee and creating a trust, which is an entity under law. This is an incredible concept because although it is kind of a fictional entity, it is respected by law. It can own property, the trust can sign contracts, the trust can employ people. It's an incredible entity available. And so, as a business attorney, when I'm working with business owners, I'm often assessing whether we should use an LLC, corporation, and within that, S corporation or C corporation, partnership, sole proprietorship, or trust. There are a variety of entities that we have available as business attorneys to accomplish the goals of our clients. Trusts provide benefits that LLCs and corporations don't have. Privacy is one of those benefits because even though LLCs and corporations need to be registered with the state, trusts do not. And so nobody may have any record of a trust. Now, of course, you can provide notice to the government. Maybe the trust buys real estate. And so now there's a real estate record with the ownership of a deed. Or maybe the trust has employees. So they have an employer identification number and they're paying payroll taxes. Or there are other reasons a trust may register. But generally speaking, trusts start out with extraordinary confidentiality because nobody besides the signer of the trust agreement knows about them. So, what is a trust? A trust is a legal, fictional entity that that exists for a particular purpose put in the trust agreement designed by you if you are setting up the trust, and you designate who can manage that. And again, that can be the trustee, which can be you. How do you hide ownership of a company? I've been contacted by clients, often in other states, who have said, I want to set up a company without having any public record of who the owner is. There are some states, in fact, many states, that require the owner to be a matter of public record. Minnesota is not one of them. So I have set up Minnesota LLCs and corporations for people who are looking for privacy and anonymity. They want it to remain confidential who the owner is of a company. Maybe that's because they have a prominent role in the community, they're a celebrity, or maybe it is because they have significant assets and they don't want anyone to know who the owner of the company is. It's also possible that the company is engaged in the type of activity that the owner may not want to publicly be associated with. So maybe it's gambling, maybe it's pornography, maybe it's nicotine or alcohol or something that for some reason the owner doesn't want to have publicly associated with the owner's personal brand. Registration of an LLC or corporation in Minnesota allows the owner to remain confidential from the public. We might also look at using a trust because a trust is another opportunity here. Now, ultimately, you usually need to disclose who the owner is to the IRS because owners have a right to profits and the IRS has a right to know who's getting profits. So usually there is a confidential government filing that notifies the IRS of who the owner is and how much profits are being distributed to the owner. And it's for that reason we might have layers of entities like LLCs or trusts if the person really is interested in preserving privacy. Now, at the end of the day, the IRS can connect all the dots. For example, if the person is a well known Hollywood actor worth $50 million, we may have a number of layers of protection in place, but the IRS can still follow those layers and connect the dots to see, let's say Tom Cruise or Matthew McConaughey or any one of these celebrities, that they are ultimately getting the proceeds from a particular business. So, how do you protect the ownership? Or let me rephrase that. How do you preserve the confidentiality of the owner of a company? You register the company in a state where the ownership does not have to be disclosed, a state like Minnesota, for example. All right, we have come to the end of this YouTube live session. Thank you for all those who were watching today. Uh, if you are interested in submitting a question, feel free to add it in the chat section below, or you can email it to me, or in the description below, there's a form where you can submit a question online. If you haven't already, subscribe to this channel so you get notifications of upcoming live sessions. And if you don't already have the free handout for common legal mistakes you can avoid as a business owner, you can get it at aaronhall.com/free. In addition to that, you will get private, exclusive videos sent only to my subscribers explaining how you can avoid some of those common legal problems. It's great having you here today. I look forward to seeing you at the next live session.